Good evening. Good to see all of you here again. Welcome to our third week of Dying Well. I see many familiar faces here. If this is your first week here, make sure you have a green folder, and all the handouts from previous weeks are on the back table there. Everybody should have two handouts for tonight that say Auld Brothers Law Group at the top. And they're on the back table if you don't have them, or maybe raise your hand and Father Ron could get them out to you. And also I want to call your attention to this 5 Wishes booklet that Marlena, our chaplain, talked about the first week. And we only had 3 or 4 sample copies. Our administrator, Carol, has made a bunch of extra copies. They're on the back. Pick one up if you're interested. Can we pray real quick? Let us pray. Lord, we thank you for this evening. We thank you that we are able to come and just have some serious thoughts and to learn a lot tonight. Give us clarity of mind and help us to ask the questions we need to ask. And we ask that you would give us comfort as we learn these things and not anxiety and stress. In Jesus' name, amen. I'd like to introduce to you all, this is Rebecca Auld. I think she goes by Becky. She's the principal at Auld Brothers Law Group, and she does a lot of work in real estate and estate planning stuff. And so I'm excited to learn from her tonight. Let's welcome her.
Thank you for having me. I'm excited to be here, and hopefully you'll be able to learn some things and take some things away with you. Every adult needs to have some estate planning, and in the process of doing it, you really look long term. What's the short term if you're a family and just married? What's the middle term if you have children? And then it goes on what your goals are and where you want to be. So it's good to have this process and to see where you possibly want to be. You know, do you want to retire here? Do you want to move? Where are your children? What are your health circumstances when you do all of this? So it's definitely a collaboration and discussion on what's happening in your life now, what do you think is going to happen in the future, and where you'd like to be. The power of attorneys, the healthcare power of attorney, and the financial are more important than anyone thinks. They're actually very much out of convenience that you need them. Everyone will need help at some point in time, financially or health-wise, and it just could be for sense of ease. You know, you have a healthcare power of attorney. You need to call the pharmacy to get a refill from your loved one. You're able to do that. You know, you're able to ask doctors questions and get those answers for you. Because without the power of attorney, even if you're married, because of HIPAA and things like that, they could deny you answering your questions. So it's definitely a good thing, to have. And same thing for your financial, even things. It's not just paying bills and getting things. You call UPMC and question a bill, if something's wrong. So both of those documents are really for the daily, the weekly, the yearly things that everyone does. Not just the big dire things that you need to do, not just paying bills and doing that, just really figuring out and managing someone else's lives. The healthcare power of attorney is all-encompassing. What I do is a healthcare power of attorney and living will. The healthcare power of attorney part of it is to enable another individual to make decisions on your behalf, to take you to doctors, to get you admitted into the hospital, all of those things like getting testing and whatnot. And the living will part of it is when you're at the end stages of life, who's going to make those decisions and what do you want them to be? So it's very clear to your family and to the doctors. Both of them are very, very important to have. The financial power of attorney in the Pennsylvania statute is very clear, and it yells at you on the first page. When you have a financial power of attorney, your agent can do anything that you can do. It's not just paying bills. They can change beneficiaries on a life insurance policy. Let's just say you forgot to add one of your kids. They can't do what they want to do, but they've noticed, hey, I didn't add, this person didn't add someone, so I'm going to include them as well. So it's a lot of that. They can sign deeds for you. They can sign tax returns as well. So it is anything that you're able to do. Talk to your financial planner. You have all of those things in order as well. So both of those are very important. Yes, Ron?
Yeah, just a quick question. So a healthcare power of attorney is part of a living will?
It's two separate things, and I like to keep them in one document. The healthcare power of attorney is the biggest thing about being able to make decisions and do things and clarification, and then the living will part of it is for the end stages of your life. Hard decisions that need to be made. What some of those are for the person to do that. So I like to have them in one thing, so they're not separate. I think it's better that way. Now, for both of the power of attorneys that I do, I don't make them that you're incapacitated, that you're not able to make decisions for yourself, because again, it could be for sense of ease. You want somebody to call because you're not sick, call the pharmacist or call the doctor. If you were to put that you're incapacitated, you would need 2 doctors to verify and say that you don't have the ability to make decisions on your own. Well, that's very hard. Getting a doctor, any doctor, to kind of say that someone does not have capacity or it is difficult. It's really hard to do. They don't like doing that. They like to stay in their lane. I think that's a very important part, that you're able to have your individual that's helping you is able to have the flexibility to help you at any time. And you can still make decisions for yourself when you're able, but they're also there to help you when you can't, or you just need a little bit of help. Does anybody have questions about the power of attorneys that I can answer?
Can they be limited? In circumstances but not other?
The financial power of attorney cannot. You could have a special power of attorney that's maybe limited for one thing. So oftentimes people will do a special power of attorney to handle a real estate closing because they're not there and they want someone to be able to sign all the closing documents. So that's very specific. But the financial power of attorney in general is all-encompassing and says that and makes it very clear that someone's able to manage all of your affairs and do anything. They certainly can't do anything that they would like to do with your funds. They have to be consistent with your needs and what you have going on in your life. But yes, so the main one, the big one is, your agent's able to do whatever they need to do for you. So, any other questions about the financial power of attorney? Yes?
How does someone become someone's power, or how do you give that power of attorney to someone?
You have an attorney draft a healthcare or financial power of attorney, and you really sit down and talk about it. Who is the right person to be your healthcare power of attorney? If it's someone who cannot make those hard decisions, maybe they're not the best choice. You need someone to be able to think about those things and effectuate what you want. And the same thing for financial. I use my parents as an example. My mom could not be my financial power of attorney because it took my dad 2 weeks when they got married to straighten out her checkbook. So she is not a good option. But my father is, because he's an attorney. But my mom's a retired nurse. She can certainly be my healthcare power of attorney. And it's good when you make the decision on who it's going to be to talk to those people, to let them know or ask them, would you be able to be my agent when I'm not able, or I need someone to be able to step in. This is you really have to go over a list of what you have. Tell them, here are what my assets are. If you need to call someone, this is who it would be for financial. And then for the healthcare, it's a very good idea to give your healthcare power of attorney to your PCP, because they're the ones that track everything you do. If you go to a doctor, everything's going transferred over to them. So if you go to a physician and they don't know you and they're not familiar, and someone needs to make decisions for you because something has happened, they usually can call the PCP and ask, hey, I have Becky Auld here. I don't know her. Is there someone that I can call? Because I need someone to help us make decisions because she can't for whatever reason. So, yeah, and it's good to have the right people. The people you need to have, though, is also backups. Usually for spouses, you're each other's agents, primary agents, and then it's usually good to have 2 backups to that first individual. And the last person, it's a good idea to have a younger generation than the prior before them, because you want it to last a very long time. You want the document to be able to use and not have to go back and change it or revise it or get one up to date. So, yeah.
And can more than one person have power of attorney, or is it the backup is only in place if the first person is not?
You can have co-power of attorneys, co-agents. The only thing I don't like about that and suggest is if they both need to make a decision or get in touch with, whether it's a doctor or at a hospital, and that can't happen, that could delay something that's pretty important and timely. And it just makes it more inconvenient for them. And same thing for financial. If you are talking to a financial institution about changing money, closing an account and creating another one, if they have to go through 2 people, it just would make it pretty timely and hard to do. But you can do co-agents for either one. But the backups are listed, your first, your primary, then your first backup, and then your secondary backup.
Would that make sense if the primary, for example, is somebody who travels out of town quite a bit, and suddenly there's a need, do they then fall to the second person?
Yep, so if the first person isn't able to act, whether they're no longer living or they just decline because of their personal circumstances, like if they travel and they're not here and it's not convenient or helpful for you, then they renounce, and the next person would then be the agent, for you. So you always have those backups in place to who that will be. Yep. Yes, ma'am.
You mentioned that the doctor could be your healthcare attorney. I can't imagine they want to do that.
No, your doctor can't be your healthcare power of attorney. Yeah. No, your doctor can't. But it's good to give your power of attorney to that person so they have it as a backup. But usually the best is to have a family member, who knows what your wishes are, and what you would like. I am seeing more and more lately children that are fighting, unfortunately, about a lot of different things. And it's just good to talk to your family, talk to your spouses about what is best for you, so there is no fighting, because it's certainly not fun, and it's very stressful on families, even to the point of what would happen to your remains when you pass away. Do you want to be cremated or buried? I have a family right now who's fighting over that, and I have to have a hearing on what that is, because the children that are in their late 50s and late 60s are fighting over what has to happen. And the gentleman passed away on September 22nd. So all this has been very stressful on his family and just shouldn't happen. That something like that just shouldn't happen.
And what does that come under? Healthcare or financial? You're fighting over burial?
Well, when someone passes away, the next of kin, everyone has the right to say what they would like to have happen. I like to put it in our health care if that's something that someone would like, to put it in there so that it's clear. I had one gentleman says that he only wanted to be cremated, and that was all. He didn't want to have a service. He didn't want to have a viewing. He was very specific in that. And then the other thing is you can also put it in your will. You can mention it there too, that this is what you would like. So, yes.
I saw that happen personally in my family, where the daughters of my sister's husband couldn't agree, so they all got so much of the ashes.
Oh, yeah. And I bet that took a long time and a lot of stress for them to come to that point. Yeah, that's stressful. It's a long point. Yes, ma'am.
The people that are power of attorney, do they need to have, when you go to the doctor, you have to fill out all those little reports about who's allowed to know anything about you? If they have that power of attorney paper, is that covered?
Yes. So if you go to your doctor and you said you can, give information to your sister, the power of attorney would also cover that too. If they need to get information or answer some questions or make some decisions, yeah, that person is able to do that. Yep. Yes, ma'am.
If you file papers here in this state and then you happen to move, can you still use that document, or should it follow you? Should you go to another state or something?
The documents themselves don't get filed, but let's just say you do one in Pennsylvania and then, a couple years you decide to move to Ohio. Will it be buy to buy? Would they use it in Ohio? Yeah, sure, they certainly would. If you're not able to do that, Pennsylvania's pretty strict on what they want and don't want, so we're pretty tight on the rules and regulations for all those things. But it is a good idea, if you happen to move, just get that changed. But no, if you had either of them done and something, you didn't do it for whatever reason, it would be able to be used. It certainly would. Yes.
Where's the best place to put these forms?
After you draft your documents? Well, some people have safety deposit boxes, and does anybody here have those? Anyone? Do you? The only thing I don't like about safety deposit boxes is if someone needs to get to it, and the bank's not open, or they can't find the key, it makes it a little bit hard. But what I think everyone does with mine is, you get this blue folder, it has everything in it. They stick it in a firebox, or they put it somewhere, for safekeeping. So it's wherever you put your documents. You also can give your agents, if you feel comfortable, a copy of your power of attorney, so then they have it, so then they know, or tell them where it is, where they are able to get it. And most attorneys, power of attorneys, say in there that copies are to be treated as an original, for both of them. Otherwise, you'd have to sign a whole lot. You'd have to sign a lot of those and have them at hand. So, yes.
I have all three of these documents. Can I just make copies of them and give them to my two children?
For your power of attorneys, yes, you could. And then, and I'm sure that yours probably says that the copies are to be treated as an original, and then you can have them. I bet it does. Yeah, I bet it does. For your will, though, there's only one original will, and you can tell everyone where that is, and make copies if you were to put it in a safety deposit box or anything like that. So, yeah, you could keep those in one place. But some people like to give it to their agents ahead of time, to the family member, or just let them know, hey, this is where it is if you need to do something for me. So, yeah.
The other issue is with the safety deposit box. If you have it in your own name and you die, and the next day your children go to the box, they can't open it.
No. So when someone passes away, and the bank knows that, they put a freeze on the safety deposit box, and the attorney who's handling the estate has to register with the state that they're going into the box at this certain bank at this certain day to do an inventory. So you can't do that right away, and it does get frozen. So then when you go to the bank and you do an inventory, they have to verify that that's what's in there. And I've even had to put pictures and photos. You really make a list of everything that's in there, so they just know that no one's taking things. Because I guess back in the olden days, people probably just took what they found in safety deposit box, and nobody was the wiser. Yeah.
Growing up in a little town with a little original bank, there was some interesting stories about safety. The bank owners found it because
They had the keys. Nobody knew. That's right.
So does
Yes.
it make sense to bring the agent with you when you're sitting with your attorney to create the power of attorney?
No, usually not. I mean, because that's pretty private and really the attorney asking you a lot of questions about your circumstance. But no, it's usually no. The financial power of attorney, the agent needs to sign it in the back when they need to do something. And there's an acknowledgement that the agents have to sign, but they only sign that when they need to, when they're doing something for you. But yeah, most people don't have their agents. They usually just talk to them ahead of time. Can you do this for me? And then have them have a general idea, what they need done. So, anything else I can answer about those things? Well, the financial power of attorney, I don't know, because they make you, Pennsylvania has in the front page and in the back, last several pages, very specific on what you're supposed to do. I don't know what would happen if someone were to do their own. For the health care, even with the 5 wishes, something like that, those don't need to be notarized. Something like that, because I think it's usually just covering things for when you're in the hospital, just to let them know. But I honestly don't know. I don't know what they would accept it. All of them do get notarized. All the documents, the 3 of them get notarized. And for your wills, there's 2 witnesses. They sign twice, and the individual signs twice, and then it gets notarized for that. So, yeah. Yes, sir.
When I got the power of attorney for my mother, my brother and I both signed it because we're not co-power, we're just both power of attorney, we both have power of attorney. But we had to take it down to the courthouse in Greensburg and get a stamp and certificate at the courthouse so that we were able to use it, because some places will take it without the stamp, but there are like insurance companies and some companies need stamped original power of attorney statement for me to sign for something for my mother.
So you had to take it down to the county and get them to serve. And it probably was recorded. It might have been recorded with them too, so that they were able to certify what it was. Yeah. All those things. Every county is different. It's always interesting to see what everybody wants and doesn't want, big or little. So, any other questions about power of attorneys that I can answer for anyone? Okay, so we'll move on to the wills, to drafting your will, and what are some things to think about. For your will, you need to think about, what are your belongings? What do you have what legacy are you giving to your family members? And who's to get anything? What are in your will? Are you putting that it's your children and what percentage they are to get them? So you look at that on who's to get everything. It's usually their spouse. The first spouse gets everything from the first spouse that passes away to the second. And then you itemize, who is to inherit once that individual has passed away, and you can put that as well. You can also put that their children would get it, that your grandchildren would get it, if your child has predeceased you. And one of the things that is safe to do is, if your grandchildren are inheriting from you, it's a good idea to have a clause that says, if they're under 25, their money is held in trust by Aunt Sue, till they reach certain ages, and they're to get a percentage or things, or they're able to use it for their education. Put a down payment on a house or start a business or something like that. So it's good to have those in place too, to have at least 2 people that you would put in charge of those person's funds because your child has passed away. So that's another thing to inherit. Inheritance tax for Pennsylvania is 4.5% for children. It's 0 for spouses. And for spouses, I think they just know when the last of you passes away, they're going to tax you then, and it's probably one of the biggest taxes you're going to have. So the first spouse does not have anything taxed. And usually the first spouse, there doesn't need to be a probate. If everything's titled correctly, everything just flows over to the spouse. So there is nothing that you need to do. But the thing I do ask people is make sure your car titles are on both of your names. And then you don't have little rainy day funds out there, that it's just one of you on it. For either of those things, if that occurs, you have to do a little bit of an estate to get that money out, or to get to be able to sell the car, or even just put their name on it. So there's little things, but if people usually do all of that in advance, then there's nothing that needs to be done. But Pennsylvania is a pretty tough state for inheritance tax, and there's things that you can do to lessen what that is, to think about what that is. For your executors, it's usually each other, the spouses are each other, but then you need to figure out who's going to be the person after you that will handle winding down your life. And they wind down everything. They close accounts, they figure out what the assets are and who they are to go to, if they're to get liquidated, and handle all of that. They really have a big task. So it's good to have 2 backups for those as well. And the last person maybe being of a younger generation. And for any of these things, for the executors or for your agents as your power of attorneys, it's okay if they're not local. It's probably out of convenience more so if they are here. But nowadays, with how things are, you can do a lot of things remotely, between telephone calls and faxing things. And, you don't have to be right here to do it, but it certainly does help. So executors do a lot of work when someone passes away. And it's usually 1.5 years, believe it or not. The biggest thing that an estate needs to do is, once they have all the assets, and figure out what they are, and figure out the monetary amount that's going to be taxed. When the inheritance tax return is filed, the state usually takes 6 months or more to get it back to the attorney who's administering the estate, which makes it a really long time. So people think, why is this taking so long? Well, it's the state that's making it take so long. They really make you wait. And the department that handles that, they're not very big. I think there's less than 10 people, believe it or not, that handles all of those. So that's the reason why it's usually 1.5 years. If you have to sell a house, it usually takes longer. If you're putting on the market and you're selling a home or a residence, it will take longer because of that. So there's all the extra things that come into place, for that. I think what else for wills? I'm going to go into actual probate. So anything else about wills, about drafting your wills? Any questions about that? Yes?
When a will gets executed, you were saying the attorney that's handling it. Does the attorney have to get involved, or can the executor, a family member, do it all themselves, or certain things?
When they're probating an estate? When they're probating?
Oh, is that that's what?
Yeah, so when your will is an illegal document until you pass away, but once someone does, you would have to do, there's a couple legal hoops that you wouldn't, no one would know how to handle it, so you'd have to get an attorney to be able to help you out. I'm sure people have, but it would have to be a pretty tall task to be able to do. So, any other questions about drafting wills that I can answer? The probate process does begin with naming who your executor is, and then getting them sworn in the county where the person has passed away. And then that individual, I call that the hunter-gatherer stage, where they get all of the debts and all of the assets together to be able to do that inheritance tax return and figure out what needs to be done with those assets. Then they file the inheritance tax return. But there's a lot into that. You have to cancel mail, close credit cards, close all those things out, and make sure that they're handled, literally everything. File final income tax returns, if that's the final one that's going to be for someone, and do all those nitty-gritty little things. So that's the biggest part, I think, for executors, is they do have to do a lot of work, and it's a pretty thankless job. There's a lot of searching through documents. And one of the things, I drafted this thing, I think it's information to be kept with your will. It's like 14 pages of homework nobody wants to do, but it really lists, what are your accounts, who are they with, who do you need to contact, what are the account numbers, these are my assets, these are my debts. So everyone's able to know. And when someone has that piece of paper, they don't have to go searching for it. And it's a little bit scary when things are going paperless, that, you might not be getting statements because they might have chosen, not to send everything paper-wise. So families have to do some searching to figure that out. So that's a tough thing to do. I think what else? Well, I think one of the main things I get asked is, is there ways to lessen inheritance tax? And there are. Some families like to add children to their homes, to their residences. And it's usually if they have one child, it makes it a lot easier. That if they add their child to their house, to the property, and it gets recorded in Pittsburgh, if you're in Allegheny County, when someone passes away, as long as it's a year and a day that they transferred the house and they added their child, at the time of their passing, only half of the value of the house is taxed at 4.5%, which could be a pretty big number. So the whole thing is not taxed. Parents also oftentimes will take themselves off. They know that they don't want to get taxed at all, so they've decided to take themselves off and give it to their child. It's a good idea, I think, if your child might want to live in your residence, if they want to stay there and make that their home. But the only hard thing is if you know that your child's going to move, they're not going to live there and sell it. If you give it to them ahead of time, and then when they sell it, they're going to get capital gains on that. So that could be a pretty big number that would affect that year's taxes, for them. So it's, it's not too often that people want to do that unless their child is going to remain in the residence or live there. You can also do that with bank accounts. I can add my children to my Mars savings and checking account. I can add all three of them. And so when I were to pass away, only a quarter of that would be taxed at 4.5%. So you can do that as well and do that. You can also give people $15,000 a year to move funds away from you from getting taxed. And you're able to do that yearly. So I could do a check on December 25th, 2021 gift to Bobby, 1/1/2022. 22 gift to Bobby in the memo section to be able to move funds away from getting taxed. So that's also an option as well to doing that. For assets that are, probate assets are assets that don't have anyone listed to it. So bank accounts, your house, your cars, all of those things are probate assets. But for some of those, for your financial ones in particular, you can already title who they're going to go to. You can already name your beneficiaries and say that I would like my Mars bank account to be transferred on death to my cousin Sally to go to that individual. So it doesn't go through my estate because you've already named prior to your passing who that asset's to go to. So that's another option you're able to do as well, is to name that person in advance. And then you can always change it. You can change that at any time. But those are, I think, the biggest thing that I get asked a lot is, how can we lessen inheritance tax? What can I do? I do think that more often now people need to look at their health, health-wise. That's really the unknown for everyone to think about. How am I going to pay for my long-term care if I need it? How am I going to pay for higher medical expenses if something needs to, come up? So when you do your estate planning and your will in particular, that's the really thing that nobody knows. What health-wise is happening to you, and will that affect any decisions that you may make? So, yes, ma'am.
That's something that gifts need to be 5 years before you die or something. My dad's a nursing home, very optimistic.
Well, that's Medicaid planning. So when someone is running out of funds and they think they may need government assistance to pay for their care, that's the 5-year look back that they're talking about. So they basically make you fill out a very big questionnaire that asks you, what are all of your assets? What are they? And even within that 5 years. So if I were to sold my house within that time frame, they're still going to consider that I have it, that I'm able to use that asset to pay for my care. And what they end up doing is they boil you down to one number, and they say, okay, Becky, you have to pay 32 months of private pay, and then the 33rd month we'll kick in and pay. So that's what they're talking about with 5 years, is if you have to apply for Medicaid, if that's something you have to do. Yes, ma'am?
Well, it seems like in our family experience, that is looked at very carefully by the nursing homes. So it may
Yeah.
Because after they actuarialize you,
Yep.
they want to make sure that they're not going to get stuck with a Medicaid payment.
Yep.
So that was sort of tricky.
An eye opener. Yeah, they do. And I didn't realize too that a lot of places take this, take all the insurance. St. Barnabas might not take Cigna. So if you have Cigna health insurance, you can't go there. So that was pretty interesting to find out that too. But yeah, you're right. They want to know everything about you before that you're in the door, if you're able to pay.
Almost had like a closing, let's just say the Ascension Home, it wasn't the Ascension Home, almost had like a closing, a real estate closing, with a representative of the Department of Aging there. And they said to us, if you have misrepresented anything, then, we will come back and your loved one will not be able to stay here.
Yeah,
So it was pretty something.
it's a little scary.
Yeah.
They kind of put that
Just basically saying, when, that bottom, you have to drop.
within that time
But
frame.
it does make a difference in terms of the quality of the place that you might be able to get into.
Right. And they can't, when you're in a facility, they can't remove you when you're in the door. But if you were to go out and to get care somewhere else and have to leave the facility, then they could say, they won't take you whenever you come back. If a facility has lesser care levels, then they probably would move you, to that area for that. So yeah, all those things are very scary. And for your family, you really have to tell them to be really good advocates for you in terms of finding a location that's appropriate for you within your health insurance and convenience of where you are. I mean, you have to really, really look and see, is this place a good fit for my parent? Do they have all the things that I think they need for their own care or just for them to enjoy? Is it a place that they like to be? And really push, and you have to do that fairly quickly. You have to do that pretty quickly in figuring out where they are to go, but you don't have to sign a contract right away. So if I decide I want to go into St. Barnabas, they usually make you fill out the contract after, fill it out after you're there and get you in the door. But you really have to look and be a pretty good advocate in figuring out, is this going to work for you? Do they also have a skilled nursing level if you need to go to a higher level, where that will be so it doesn't disrupt where you are? Do they have a memory care unit? What's the best place for you to actually be? And you have to really talk to the social workers, I think. Let's just say I have physical therapy and they scheduled it for 10 o'clock. Well, I'm not up at 10 o'clock, so I need it after lunch. You really have to ask them, what schedule do they have planned out for your loved one? And does that work for them? Is that going to be practical? And pretty on it with them, really checking and seeing what they're doing and making sure that those needs are met. So that's a lot of work and a lot of figuring out. And unfortunately, it seems like people find out as they go, but they get something that they don't want. They're having to make decisions or do something, and they found out too late that this isn't an option, or I can't do that. So it's a scary experience, and everybody I think is different on what they need to do.
I was wondering if some of these homes that we see that are vacant, or across the street or something, if it's because the senior or elderly is in nursing care, and until they pass away, they can't sell that home?
Yeah, if that could be one of the reasons they have it, and they can't sell it, the estate wouldn't be able to sell it until that person passes away. But usually that is if someone has applied for Medicaid and they need to be repaid, it's usually the residence that does that, whatever funds. And a third-party claim would be submitted by the state that says, $66,000 needs to be repaid because that's what we provided. That's the amount of money, and they give you bills of what that is.
So they can't sell the house generally until the person passes away?
Right. And if your spouse is living there, they can't make that person leave. And sometimes they'll even wait till that person has passed away. They don't want to kick them out of their house. They don't make someone leave, or the spouse that's still being home.
But someone with the agent on the financial power of attorney would have the authority to sell a home if that was recommended, right?
But if they had to apply for Medicaid, it'd be pretty tricky to do, because if they didn't get the best value for it. So in that instance, they probably would be a little bit more conservative on doing that. So that would be a hard question. That would be tricky one to think about it now. Yeah. Yes, sir.
One thing I found out, my sister-in-law, she was living in a house with her father, and taking care of him for another year. So when he went into Medicaid, they were able to keep the house because they had been providing for their care. So if you're, living with somebody in your house, then you get inherently the right to that house.
They can go back and try to get it, though, eventually after you have passed. But yes, in most circumstances with children moving back and helping their parent, they're able to stay there. Yeah. Right.
Going back to the insurance, I ran into a situation with my mother. To meet the $5,000 limit for Medicaid, I have to cash in her life insurance policies. She has a number of life insurance policies, and I have to sell them off in order to get the cash to get her down to $5,000. Now, if I had known this 4 years ago or 5 years ago, I could have changed the owner of the policy to either myself or me or my brother. And then since we would have been the owners of the policy, they wouldn't count as her assets.
That money.
Since she's still the owner of the policy, they have to be cashed in.
Did they have to use that as a spend down? Is that money that they wanted to be used?
Yeah.
Okay.
They have to be, because they're, like $10,000, and that's over the $5,000 limit, so they have to be cashed in to get rid of below the $5,000.
Yeah. No, it's-
That whole life insurance and term life.
It's a term life policy, yes. That was bought for like 5 cents a day back in the 50s. And it's paid off, but it's accumulated interest since my dad bought them. And they're like you said, like $10,000 now, and they want a $500 policy back in the 50s. So I have to surrender them to get the cash value from them now.
yeah, that's a shame. Yes, sir.
So if I have one of those that my dad bought me when I was born, would it be better to just put one of my daughter's names on?
To change it from you, I don't know. I think it would be, yeah. I actually, I didn't know that you can do that. You can change owners of the policy
Prudential will allow me to change the
to do that.
policy because I'm the power of attorney.
Okay.
And then I'll, put it in my name, but I can't do that now. It's too late.
Yeah. It's too late. Anything else that I can answer about? Yes.
The life insurance question. So if you have a life insurance policy and you've named the beneficiary, like the case that he brought up, they can still make you cash that in. So your beneficiary basically is going to lose out on the policy. In my understanding, that's how it would work.
Only if you're applying for Medicaid.
Right?
Yep.
So even if she had beneficiary's name, it didn't matter. They still cash it
Who's
in.
the owner of the policy?
Wow.
Yeah, they'd expend that, which is unfortunate.
Yeah.
Yeah, they'd expend all that.
Can you use some of that for funeral expenses? Can you prepay a funeral fund, like something like that? And then not-
Yeah, you can prepay funeral expenses. I don't know that you can do it with life insurance monies. I think it would have to be a specific type of policy to be able to do that. But you can do that as well, which is a good idea.
Medicaid doesn't count prepaid funeral insurance, it's $45,000.
That's good.
Did I hear you correctly, if you're in a nursing home and you fall and break your hip and you go to the hospital for surgery, they have the right not to take you back?
They do, because if your circumstances changed in terms of medically what you needed, they could. I think they look at what's going on with you. Is it the same that they have, that you're able to go back to the facility? in terms of, what you would need, I think usually specifically.
So if they could not meet the new level of care that I need, they could say, don't come back here, find someplace else.
Yeah, go to a different, and hopefully they have a different area within the organization that you'd be able to go to. Yeah. Yes, sir. Anything else I can answer? Wanna talk about? It does take a lot of forethought with doing these, and it's certainly not fun. But I think it gives people peace of mind when they have it done. They know they have an action plan of what they need, and they have it if they need it, and it's already in place, and they have an idea. So it's getting more organized, having all those things in place, just to kind of know what needs to happen when, and you've had some forethought about it. So it's good to do. It's just good to pre-plan and have some of those things in place. Yep. Well, I enjoyed so very much talking to you all. I hope I helped a little bit with giving you some information about some things to think about. Yeah. If you have any questions, I'll certainly answer them too after.
Could you say a little bit about what living trusts are and why you would use them?
Living trusts, I always ask people, what do you want it to do? Is there something that you would like it to do? What do you want it to accomplish? For living trusts, is there a disability? Is there a special needs trust that needs to be in place? Is there something like addiction that needs to be considered and thought of? What are some other of those things? And then people can do it even, that's where they want their funds to go to be controlled after they're passed away. All the assets for XYZ children or grandchildren are going to be held in trust, and then they're to be given off in terms of what the trust rules are. So you can't have trust. But for a lot of people, if it's less than $800,000, which I know is a lot of money, you're creating something that's an actual thing, like a business. It gets its own EIN number, employer identification number for the federal government. So you've created something that one needs to be created, and if it's getting gains and losses throughout the year, you have to do yearly income taxes, both state and federal. So sometimes it's just more cumbersome than really what it's worth to do, for those. So you really have to think about is that the right choice, a practical one. But they are good for specific reasons for worrying about disability and addiction or something like that. Mm-hmm. Mm-hmm. Yes.
Can you avoid probate by setting up a trust?
You can, but you basically, everything would have to be titled into the trust name before you pass away. And in essence, then you'd have to basically be a pauper. Everything would have to go there. You can do it. I think it's hard for anybody to do that. It would be difficult, but you can even put your house into the name of the trust. So, did you?
Are there any major common mistakes that you see people make in your state?
I think it's usually about picking the right person and having those right backups, and that's just pretty specific to you and to those individuals that you have. I tell people, do not be an ostrich. If you think that there's going to be a problem with your children, or if something's going to be an issue, don't be an ostrich, because it's probably going to happen. If you're worried about something, there's a good chance that it might happen. So just avoid that. Don't have guilt on naming this person because they're the oldest. It's usually just not a good idea. And specifically for wills too. Don't make your executor your oldest child because you think that they're going to get upset. They can be upset, but you need to pick the right person who's able to do that. Yeah, I think it's usually picking who your agents are going to be, what is the right person for you. So, yeah.
I've seen online like I don't know, legal Zoom, websites that say like, oh, we can do some legal documents for you. Are those ever a good idea? Or I've heard you talk about like conversations more in depth than I really thought attorneys did.
Oh yeah. Yeah.
Are there cases where that might be good or?
The only thing, I usually spend a good hour with people, and I'm asking you a lot more questions than you're asking me, so I can understand your situation, your children, where you are, what are your goals. The only thing I don't like about, when you do that type of thing is they don't know a lot about you. They're only knowing the limited things that you're telling them, and is that really, a good idea? Do people use them? Yeah, but if there's something that you didn't think about that was important, or you might have a different idea on, you don't have anybody to ask, answer those questions and think about. But yeah, people do it. I know a lot of people do it, and they certainly can. So. Yes. Yeah. Go ahead and do that. Yeah. So. Anything else that I could answer? Anything legal? Yes.
It's not really a question, it's a quotation from my grandmother and her generation. Growing up in a rural, everybody was poor environment with people that survived the Depression. My grandmother's phrase was, "Die penniless, your children will love you." And that was what those farm families did. Every year they gave a piece of the farm, to whichever child was going to inherit it. So by the time they died, they were living upstairs in the house of the child.
They got it. That's what I tell people. Use your funds. Nobody's usually expecting anything for you, so use them while you can, do them what you can. And that reminds me too, if you have things that you specifically in your will you want to go to someone, let's just say I have an expensive painting and I want it to go to my son Everett. I don't like putting those in your will because then the state thinks that's worth a lot of money. It needs to be taxed. I'm going to tax that. So in the packet that I have, and people usually do, you can put a piece of paper and write if you have specific things that you want to go to someone, and then the executor will make sure that happens. So you're able to have that, and you can change it. My advice is give it to them in advance, so then they're able to use it.
Slips of paper and tacking it on the back of the pictures, unpacking the statues, unpack off furniture. This is to go to Janine. This is to go to Kelly. When we went in the house after she moved out, everything was already labeled as to who it was to go to. Whether it's a donor for 20-something years previous.
I bet everybody appreciated that too. There was no question. You didn't have to fight over that clock or who's getting it. Yeah, that's true. Yeah, that's funny. So,
One question
yes.
about willing to non-children, like to estates or to your churches or to charitable organizations. Do you have any suggestions on that? There are a number of people that don't have children to give to, and
Well, charities aren't taxed. So if you were to give your estate to a charity, a nonprofit, that doesn't get taxed, so they're able to have that. If you are giving it to a charity and you have other people as well, if it's over, I think, $10,000, the Attorney General's office has to actually know that this is going to a charity, and you kind of have to go through them to show that they actually got the money that they got what you wanted for them to have. So that's a little bit of a pain. It's an extra hoop that you have to go through. I don't like having to go through the Attorney General's office. But yeah, if you have no other family and you're giving it to a charity, that's fine too. You just list it. I like to list the name of the organization and the address, and then put, should this charity no longer exist at the time of my passing, I would like it to go to something similar to what their cause was and what they did.
Then who would make that decision?
It's usually the executor and the attorney, just figuring out where that would go, who it will go to if they're no longer in existence. Yep. Anything else?
When you do your will, is there a specific amount that should go to your spouse and your children and so forth so that the will doesn't get contested?
Well, when the first spouses pass away, the surviving spouse gets everything. They get everything. And then usually what everyone has is it gets percentage by their children, by percentage what they are to get. So that's usually what everyone does with their assets.
If somebody passes away with no assets, does an inheritance tax return still need to be filed?
No, because they don't have anything to tax.
Okay.
Yeah, so you don't have to worry about it. Yep. Yeah, no return.
And you have to have a will to pass it on to your spouse.
No, not necessarily, because if the car is titled and the bank accounts are titled in each other's name, it just goes over to the other person. And there's some people that don't have wills, that don't draft them, and it just transfers over. So you don't have to do anything. You don't have to retitle your account. You don't have to get new checks. You don't have to do a new deed to reflect that they've passed. Everything just goes right over. You don't have to do anything.
I had my daughter on my bank account's number, and I would advise to take her name off, because she could be taxed pretty highly. Also, and she has a very good marriage, but if her husband and she got divorced, he could have access to half my bank account.
Right.
So should a bank account not have somebody like my daughter on it because of the ramifications of taxes?
Well, the taxes would only be if she were to predecease you, your money would get taxed. So that could happen, and I know that's happened, I think, once or twice that I know of. And then the situation of divorce, that if someone were to get a divorce, that asset's going to be, half of that's going to be, part of hers as well.
But if I die and she is on my bank account, then she gets taxed
4.5% for the half of it,
bank account because she's co-owner.
but only half of it. So if you were to add her, the benefit would be at the time of your passing, if it's got $100,000 in it, only $50,000 of it would be taxed.
But if she's not on it at all, if it's only in my name,
All of it,
then the taxing goes to,
4.5%. Yep, to her. Mm-hmm.
so it's better not to have money on it.
No, I think it depends on how many kids you have.
I have 3.
Okay, then that's probably hard because you have 3 kids. But that's the only benefit. If you add them, or you add one of them, you save in tax. If not, then your estate has to pay that tax. So I think it just kind of depends. I do think it's hard whenever you have more than one child. That does make it a little bit trickier to do that.
Well, I have a will and it's divided, third.
Mm-hmm.
But if she's on it, then she would be co-owner.
Then she would get all of it. Mm-hmm. It would be taxed at half, but she would receive, it's now all of her funds now. So it wouldn't go into your estate and be divided into 3. That account would be solely owned by her. Mm-hmm. Well, hopefully at least half would be taxed. Yep. Yes, sir.
One of this lady's questions here, say you and your daughter on a bank account, $100,000. You pass away, you primary. So automatically your daughter or your child, whoever on has $50,000. That's not taxed, is it?
The half of it, if there's a...
You have $50,000 on
Yep.
tax, am I correct?
Right.
But the primary is $50,000 would be part of the estate, so that would be taxed.
Right, so the half of it the other half is taxed 4.5%, but it's that child's all their money, but it does get taxed. Yeah, yeah.
Is the inheritance tax rate the same as if you have a child as a joint account holder and the child predeceases you?
Because they would be taxed at whatever their rate is. So if you'd be getting taxed at your own money, but it would be who is inheriting from that individual, what would the tax be on that? So that's the unfortunate part. There'd be a tax on your own money, which is not good. Would it be likely to happen? Probably not, but it would be a sure kick if you had to do that, if you had to pay that. Mm-hmm. Mm-hmm.
And just to confirm, if the account was for the spouse, there would be no tax involved.
Right, because spouses are not taxed on anything that you have or not. There's zero tax for spouses because they know they're going to get you when the last of you passes away. Frankly, they know that we're going to get that, and it's a big. You think about how many times your money's been taxed. A lot of the time. So my goal with this estates is, can we give them the least amount as possible? What we can do so they don't get all that any more than they certainly don't deserve. So, yeah. Yes. Yep. Move to Florida. Yep, Florida would be a good place. Yeah. So, anything else? Well, thank you guys so much. It was nice coming. It was nice being here.
And please join us for coffee and cookies and other drinks.